All right. Now, of the recent dates we've had of cases where, cases at the corridors of justice are not ending and the prisons are becoming too congested. Hence the reason as to why recently the Director of Public Prosecution Office launched a plea bargaining agreement. And let's talk now to the Director of Public Prosecution, Odin Haj, who's joining us now from our Kisumu studio. And thank you so much, DPP, for talking to us here on KTN News Center this morning. Let's talk about the plea bargain that was launched this week. What is it all about?
Thank you, Brenda. Plea bargaining is all about alternative to prosecutions, finding alternative ways to, one, decongest, two, fast track some of the cases that we have. You know very well that we've had a lot of backlog both in courts and in processing cases and prosecuting. So we are trying to find alternative ways to declog the courts and make sure that they're able to deal with matters that are of importance. Not that other cases are not important, but matters that are complex and really need the input of the judiciary. So plea bargaining and diversion policy, which we recently launched, are geared towards ensuring that cases are dealt with effectively and in an expedited manner.
All right. Now, you've explained for us about what plea bargaining, agreement is all about. But in the theory, has been part of the criminal justice system. But for a long time, its application has poorly been utilized.
You mean the plea bargaining itself?
Yes.
Yeah. So it is true that it has been there, but for a long time they were not regularized, and guidelines were not given on how best it can be used as a tool in ensuring that prosecution and the criminal justice system becomes more effective. So in essence, what we've done is we've come up with the guidelines. We've come up with a system that will ensure that plea bargaining itself has integrity and it is done for the benefit of Mwananchi and not a few individuals. And this is where we are, sensitizing the public, sensitizing prosecutors and the stakeholders who, at the end, intend to use the tool.
All right. And what happens next? What happens if one fails to, to honor the plea bargaining? What's next for the accused?
Of course, you go back to trial, and you go back to court and proceed from where you left. It's an agreement, and if an agreement is breached, then there are remedies where you can go back to ensure that whatever you have is then properly dealt with.
All right. Now, thank you so much for, shedding light about the plea, bargaining agreement that was, that whole guideline that was launched on Wednesday last week. But let's talk about matters corruption in the country. DPP, there's been a lot of concern in terms of how your office has been handling some of the evidence that has been, brought to your office. But as we speak right now, how many corruption cases have been taken to court across the country?
Well, there's quite a bit. But if we were to talk about 2018 to date, since I took office, over 180 cases have been brought, and quite a number of high-profile cases have been taken to court. I know the issue of conviction is what Kenyans are anxious about. But this is a matter that is not only at the hands of prosecutors. You see, the criminal justice system has a process. You start with investigations that are done by the investigators. Then the file is brought to the prosecutors, who then decide whether there is enough evidence and whether we can present that evidence in court for prosecution. Once the threshold is met, then it is forwarded to the judiciary, to the courts. Then it is the courts who have to sit down, give us dates, give us rooms and give us courtrooms and give us magistrates or judges to deal with. And it is here then that you can be able to get convictions. Convictions does not lie in the hands of the prosecutor. It actually lies in the hand of the judiciary. And we understand that that the Chief Justice is trying his best to ensure that in graft cases we have enough judges and magistrates to sit down and listen to the case in an expedited manner. But let's not also forget that there is a constitution, and the constitution gives an accused the right to have a defense lawyer, to be heard, and the individual is innocent until proven guilty. And therefore, we cannot try to infringe on that right. We have to respect it. And I think so far, Brenda, you have seen that we as the executive, and especially the prosecution, we have been respectful to court orders, despite the fact that there have been an impediment to prosecution.
Okay, just
we've been respectful.
Allow me to cut you short. Just before we delve into, the sort of evidence that's, being tabled in the corridors of justice, because that also has been a concern for the Chief Justice, David Maraga himself. Let's talk about some of the files that have been brought to your office by the ESCC. How many files are we talking about ever since you got into office? How many files, when it comes to corruption cases, are you handling at the moment?
Brenda, there are quarterly reports that are given by the ESCC. On how many files they've submitted to us. They have submitted over 1,000 files that we have to review. And not all of them are prosecuted, for example. Some are closed, some are taken back for further investigations, others are afforded for prosecution. So there's quite an array. It doesn't mean that all the files brought by ESCC necessarily end up in prosecution. Now, the evidence that people keep on arguing, I think that needs to be interrogated a little bit more. There have been convictions. If you look at the beginning of this year, there have been quite a number of convictions, even though they are small cases, but there have been quite a number of convictions in relation to corruption cases. Then you cannot argue, or individuals cannot argue that the evidence is wanting, when we've hardly been able to finish a lot of the cases in court. So, for example, like Goldenberg, or cases like Anglo Leasing, to date, over 10 years, some of them over 15 years, they are not complete. So how can somebody say or stand up and say that the evidence is wanting? That needs to come out in judgments. It needs to be pointed out so that we are able then to correct whatever evidence that the judiciary or others feel is wanting. Right. Just to give a blanket accusation is, I think, is something that needs to be interrogated much more, especially by the media.
All right. The reason as to why I'd asked you that is because, recently we also had President Uhuru Kenyatta, attacking the judiciary, saying that, how they handle some of the corruption cases, especially handling, high-profile people in the society. It's been wanting when it comes to issuance of bail and bonds. But also, the CJ came to the defense of the judiciary, saying that some of the evidence tabled is shoddy. But right now, you're coming to the defense of your team, saying that you need more time also to conduct investigations. Hence, my question, then why arrest an individual before... Allow me...
See, if we need... Yeah, go ahead.
Why arrest an individual before you finish your investigation? Because we've seen several times when your officers go to court, we've seen them request for 21 days, 10 days, 15 days to conduct investigations. So why not conduct investigations first, then arrest the person, the accused, so that by the time your team is going to court, they should not request for more dates, to conduct investigations?
So, Brenda, for example, we have a terrorist out there, and and you have reason to believe that they are likely to blow themselves up. You have evidence, but it has not necessarily reached the threshold. You know that you can get more evidence if you are given time. Do we let them out there continue with their plans? Or do we take necessary actions and ask for custodial orders? Those are the questions that we need to ask. And if you look at graft cases, for example, we have not done any of that. Whenever we've gone for graft cases, we have the evidence and we are ready to proceed. It is issues like murder, terrorism, or serious organized crime that then we come in and step in and say we need to have more time to investigate, but at the same time ensure that this person is not out there either to interfere with investigations or carry out and finish a certain crime or commission that is likely to occur. So, Brenda, you have to look at the situation. And I think what the president is also saying is that when it comes to separation of powers, you have three arms of government. You have parliament that legislates, you have the executive, and you have the judiciary that interprets. So in most common law jurisdictions and democratic countries, the separation of powers are really respected. And each arm tries very much to restrain itself. But increasingly, when you see that the executive role and the executive power to execute is interfered with, then the balance of the arms of government will be skewed.
All right.
And what we are saying is we need to have it balanced, and we need those separations to be respected. And interference of the executive or the judiciary or or parliament should really be a last recourse.
All right, and when you talk about interference by the executive or the judiciary, let me touch on interference by the judiciary. And we have seen this as part between your office, the office of the DPP, and also the judiciary when it comes to handling graft cases touching on judicial officers.
So, Brenda, what's your question?
My question is, you have been having a concern, the office of the DPP, which
yes.
you're the Director of Public Prosecution, has a concern on how judiciary has been handling, some graft cases against some judicial officers.
Well, yes, and this is something that we are working towards. We are sitting down with the Chief Justice, and very soon maybe also the Judicial Service Commission, so that we agree. What are some of the matters that they as the judiciary feel has to go to the JSC, even though the Constitution is very clear, that is gross misconduct and administrative issues. We have also to agree on what constitutes a criminal conduct by the judiciary. We are all Kenyans, we are all humans, we are all under the Constitution. And you cannot say that a judicial officer cannot commit a crime. They can, just as much as a prosecutor and the police can. And therefore, what we are saying is we don't want double standards. We don't want double standards. We want everything to be applied. We appreciate that the judiciary is guarding its right to discretion, and we appreciate that, and it is not our intention to interfere. But where we feel that a matter is criminal, I think the best way is for us to deal with it at the trial court and dispense with the issue there.
All right, and you've also...
Yeah. Please go ahead. Sorry.
You've also had a concern, still touching on how the judiciary handles some cases when it comes to, senior people in the society, senior politicians, senior leaders in this country, when it comes to matters graft and also some of the judicial officers. There has been a concern from your office and also from the president on the terms of bails that have been issued? Because Kenyans are saying...
Yes,
because Kenyans are saying that some of the bills that are given to, some of these top officials in the country are so lenient, yet when a Kenyan commits, an offense, they are given a stiffer penalty.
Yeah, Brenda, and this is an issue that I've tried to bring for discourse so that we can discuss as a country. But I must defend the judiciary because the Constitution itself outlines very clearly that bail is a right. And unless you have compelling reasons as to why the person shouldn't get bail, then that's the time the courts would limit that right. So really, it's an area that is constitutionally provided for. Again, it's not our intention to infringe on that, but when we feel that the right to bail needs to be limited, we bring it out, and we try and argue it out in court. The discretion lies with the magistrate and the judge, and we respect that. We probably need to come up with new laws and maybe guidelines on bail and bond. And I think the Chief Justice himself is working on that.
All right. And when we come to the tradition of what Kenyans called as Kamata Friday, arresting the accused on Friday, what do you have to say about that? Was it successful?
Brenda, you should tell me. You're the media and you're the mwananchi out there. One of the reasons why we went for this so-called Kamata Fridays was because we needed to process. We needed to get extra statements. We needed to prepare. And because we've had a huge number of accused, we needed to work through that Sunday. The Constitution provides for it. We didn't infringe any of the rights, and we thought it is a good process, and we'll still use it where we have complex cases, and we need time to process.
So does it mean, are you trying to say, DPP, that when you still need time to process, some of the accused, the allegations that have been leveled against them, because they are innocent until taken to court to proven guilty, that cannot be done on a Monday, Tuesday, Wednesday, or Thursday? It has to be done only on a Friday?
No, because of the 24-hour rule. And as I said, it depends on the complexity. And sometimes when, whether the person is cooperative in making statements and giving the evidence and preparing.
All right. And let's talk about, a lot of political interference. We have seen yourself and your counterpart, the Directorate of Criminal Investigation, George Kinoti, being attacked by politicians, being accused of being used by some political class to attack, or not really to attack, rather, sorry for that, to arrest some people based on the political affiliation or the region where they come from.
Brenda, I think that is a lot of hula baloo and a lot of lies to the public. At the end of it, if you are to look at the numbers, the figures, and the individuals, you will see that there is no particular community that has been targeted or is being targeted. A criminal is a criminal. They do it individually and not as a community. We understand as prosecutors that it comes with the territory, and increasingly we have thick skin, and we understand that we will be accused, and all manners of accusations will be leveled against us. But at the end, it is the case that will be before court that will determine really whether an individual is a criminal or not.
All right. And lastly, DPP, as we bring this conversation to an end, recently we've seen you and your counterpart, again, George Kinoti of the DCI, working very closely with FBI when it comes to handling some corruption cases or some, cases to do with drugs. How successful has that been? And also, lastly, How can you term your tenure in office so far? Have you been successful? What legacy do you have so far?
Brenda, the last question, I think it will be fair only for it to come from the public and not myself. But I've tried my best, and I hope at the end of my 8 years, Kenyans will be kind. On working with the DCI, we've worked and still work very closely, but not only with him, we also work with the EACC and also other multi-agency agencies. And we have created, as I said when I was coming into office, cooperation, collaboration, and coordination. And we've managed to do that within a year. There are teething problems, but we are working towards it. We've had a lot of international support. We are still asking for more, especially when it comes to building capacity on tracing and dealing with proceeds of crimes. We so far have very good analysts and individuals that are now able to investigate and get to know where the proceeds are. However, you still need a lot of international support because some of these monies that have been stolen are taken and stashed elsewhere out of the Kenyan jurisdiction. So we are also working into how best we can build international cooperation. Hence, a lot of us have been going out there to try and reach out and ask for help. We are a global village, so you need global support in some of these issues.
So as we talk about, working with other multi-agency teams like the FBI and also the local agency teams like the DCI and the EACC, have you been able to recover the billions of shillings that have been lost, especially the ones that have been stashed internationally in other countries?
We've been able to trace. Recovering is also a process. We still have to go to court and prove that those were proceeds of crime. We've been able to arrest some of them before they're taken out. And at some point, I think His Excellency the President will show the Kenyan public what exactly we've been able to do, maybe at the end of this year. We've also been able to be very strict in terms of how money is laundered in Kenya. I think we've managed to stem that quite a bit. And we've been working with both banks and other financial institutions towards realizing that.
All right. And, I told you that this was, the last conversation. But as we wind up, DPP, you've talked about working with, local banks and also international banking institutions. But let's talk about the local banks. And during the NY scandal, we saw several banks, you wanted them to answer to questions of money laundering,
yes.
helping some of the suspects to, steal from Kenyans. So some of these banks that you're talking about, what stringent measures have you put in place to ensure that banks actually help with investigations and actually raise alarm anytime large transactions are made when it comes to, government institutions?
Yeah, Brenda, first of all, what we've done is, for example, we are working with Central Bank and FRC, the Financial Resource Center, and the banks, and the Kenya Bankers Association also, and we've met severally. The banks that have been involved in infractions, we are now involved in what you call deferred prosecution. And that means we are going to defer prosecution in turn, they will be paying fines. Some of them have already paid hefty fines towards the central bank, but we are also in negotiations with them. And this is necessitated by the fact that it's a bank, and you cannot put a bank in jail, for example. So in a lot of other jurisdictions, the UK, the US, you have what you call deferred prosecution, which is another alternative, like plea bargaining and diversion, where we sit down, we find them, and then we give them stringent measures that they have to meet, and they are continuously monitored. Failure to which, of course, the hierarchy, the seniors, will have to answer to it.
So how many?
This is also necessitated by the fact that we don't want to stall businesses in Kenya. I know there have been, because of this, the banks have become so strict, but we are also having another round to sit down with them and ask them not to inhibit a conducive economic affair and business. And they only need to report what we call suspicious reports. So when you have business individuals, or you have individuals who have continuously been banking over the years consistent amounts, then they really don't need to be hassled. It is suspicious transactions, those huge amounts and those huge cash withdrawals, that need to be reported. So we are sitting down with the banks to tell them they need to ease in some of those very harsh requirements that they have recently put on Kenyans.
All right. All right. Thank you so much. Yeah. The Director of Public Prosecutions. Thank you. Director of Public Prosecutions, Nordin Haji, talking to us from Kisumu studios when it comes to that, plea bargaining guidelines that was launched on Wednesday that will help in terms of, trying to ease and decongest the prisons and also bring to an end several cases in the courts, and also talking to us about matters corruption, how successful it has been in the fight against corruption and money laundering in